Court is now in session. Please be seated.
Good morning again. I think you were both here when I went over the rules, so I won't go over them again. The next case that we're going to hear is, I hope I say this right, Howe versus Zhang, 24P209. Counsel, good morning.
Good morning, Your Honors. May it please the Court. Tyson Ince on behalf of Dr. Zhang, who is the appellant, appealing the modification judgment entered by the Suffolk Probate and Family Court on December 12th of 2023. Dr. Zhang is appealing that decision based on the issue of durational limits of alimony. Procedurally, the case was a bit unique in that the durational limits had not expired at the time that the complaint for modification was filed.
So that's my first question. During the pendency of the case, the time passed.
That's correct.
Didn't seek to amend the complaint.
There was not an amendment to the complaint, nor was there anything filed by, any type of a counterclaim filed by Ms. Howe.
I'm less worried about the counterclaim. I'm wondering why he didn't, or at least at the close of evidence under Rule 15, move to amend to conform with the evidence. I mean, that seems to me his cleanest path.
Agreed. And there was...
And I know you were not trial counsel, so I don't mean to shoot the messenger.
And I have spoken with trial counsel to try to get some understanding of that to help this court. The understanding, or the issue was confusing, I think, for all of the parties involved, both trial counsel and the judge, just prior to the trial starting. And when you read the transcript, and the judge herself, I think, was slightly confused as to why we're here and what we're doing here. It was raised by my brother that it was a durational limits case now, and that there didn't need to be any type of affirmative complaint or anything filed by his client to do so. The judge, I think, understood that and said, okay, well, we've got parties here, we've got evidence, we've got a complaint for modification, let's hear the case. And the judge did do that, and in the findings, it's very clear, in my view of the findings, that the judge evaluated the case under a complaint for modification, looking at a material change in circumstance. And she relied heavily on the 2021 judgment as the sort of benchmark and made comparisons to the present time. And most of that findings of facts and rationale lay all of that out in quite a bit of detail. And then at the very end, she finds that the durational limits should be exceeded. It's warranted, I think is the word she uses, in this case. Mr. Zhang's issue with those findings is that the judge did not apply the statutory structure for durational limits. Section 53 of Chapter 208 sets out 8 factors that all must be evaluated according to the case law with Hassey and with George.
So is it possible to, I'm sorry.
Go ahead.
Is it possible, though, to sort of, well, she didn't state specifically, right, as you pointed out, those statutory factors and how they applied, and while the findings didn't indicate, you know, the words in the interest of, you know, justice and the fact that the recipient had the burden of making the showing, is it possible to read in her findings of fact, though, sort of implicit, you know, her factual findings stating the fact that the recipient's, you know, current state, financial state as compared to the plaintiffs, and is it possible for us to sort of infer or make inferences, right, from those findings that she was in fact aware?
Well, in part, I think it is, but not enough to sustain the verdict or the judgment that the court entered. The evidence, when you look at the evidence that came in that the judge considered and her rationale and findings of fact, the first factor, which deals with age and illness and health issues, certainly there was testimony about that. And the 8th factor, talking about a party's own ability to provide for themselves, there was some testimony about that. All of the other factors, there's no testimony from Ms. Howe, who has the burden.
You don't have to you don't have to have all 9 factors present, right? It's possible in a particular case to have just evidence on one, and wouldn't that be sufficient to make a finding?
I think the case law, particularly in Hassey versus Hassey, says that all of the specified factors must be evaluated. Now,
in terms of evaluated, yes, but in terms of actually finding evidence to support a specific
I would agree with that. But in what we have from the trial court here, there's no indication that there was any consideration of any of those other factors. There was no evidence for the court to consider them. And so I don't know that the trial court has evaluated the factors as the statute wanted or requires. I think what the trial court did was evaluated the evidence against the standard complaint for modification, is there a material change in circumstances? She found there to be no material change and then said durational limits, exceeding the durational limits is warranted. But I don't know that the analysis that she gave was really a durational limit analysis. It looks different to me.
As I read George, the Supreme Judicial Court said in that case, the judge must consider all relevant statutorily specified factors. And then as I look at the factors, I would agree with Justice Tan's question that, number 1 and number 8, even though not identified by number, are discussed in the findings. Would you agree with that?
I would agree with that with one caveat.
I didn't see anything in the record, but I could well have missed it, that would indicate that numbers 2 through 7 were relevant in this case and ignored. Is there something in the record that calls into question whether those things should have been discussed?
I think there is, at least with regard to factor number, I think it's 5, with
Sources
unearned
and amounts of
income.
unearned income, that one?
Trial counsel did, on cross-examination of Ms. Howe, inquire about whether she had other sources of income or ability to work. There was some questioning on cross of that. There was no testimony on direct with her to prove her burden of that, but it was raised on cross. The other issue that I have, I'm sorry, was there a question?
Oh, I just want to make sure I'm remembering the same thing that you're talking about, which is a question about her ownership, her part ownership in a Chinese company of some sort, and then money that she had received from friends and family that I think at least some of which was listed as loans on her financial statement. Is there something I'm forgetting?
There were also questions whether or not she was receiving some type of Social Security disability or any private disability, to which she answered no to those questions. So it was explored briefly on cross if there were other sources of income that might, even income that could be attributed to her in some way, which of course the trial court did not do. The one other issue I have with the evidence...
Before you get to your one other issue,
oh, sure.
I have sort of a two-part question. I think about this case in the way I think about sort of a straightforward 20834 asset division, and the statute says the judge must consider the following factors, and the judge has to say something about each factor. They may say it doesn't apply or it's not relevant to this case. Here, if I read 53 the same way, to say the judge must, then to Judge Hirschfang's point, there's some factors that the judge didn't address. So, I guess it's one question that's a long one. If you agree with that premise, then why isn't this simply, nothing's ever simple, but simply a remand for further findings in light of the statute as opposed to a reverse?
Well, I agree with the premise, first of all, Your Honor, and because it doesn't itemize out factors 2 through 7, even if the judge had said, I've considered them and I don't find them relevant here, this would be a very different analysis. But because it doesn't say that, I interpret what the judge did, what the trial court judge did, was look for material change in circumstances and then at the last.
Well, she does say, in the interest of clarity, I'm considering both. And
right.
Let's assume for the sake of argument that material change in circumstance here doesn't fly, and we're really just looking at durational limit. Why wouldn't we simply remand it for further findings?
So it could be remanded for further findings. I think the reason it doesn't have to be remanded for further findings is because even if it's remanded, Ms. Howe didn't meet her burden. It's very clearly her burden. And I don't believe there's enough evidence that meets that burden, even with the limited factors. And that points back to the caveat I wanted to mention. The medical evidence that we heard with regard to Ms. Howe was primarily from medical evidence that issues she had from 2007 to 2013 with one diagnosis she testified was ongoing to present day. The case law is clear that the factors have to be considered at the present time, not at the time of the divorce or any other time. This court just recently issued an opinion in SS versus SS that addressed that issue exactly on point, where durational limits were exceeded at the time the divorce judgment was granted. And this court said, no, that's not the appropriate time. It's at the time the limits expire that the court's got to evaluate that. I don't believe the evidence that was presented at the trial for the trial court to consider, particularly to the first point, was sufficient to establish at that point in time The limited medical evidence that Ms. Howe presented to meet her burden was much older evidence, sort of over the history of this party's post-divorce or even pre-divorce time period. There was not anything sufficient, I believe, to support durational findings on that factor, which of the two that were considered, that's, I think, the bigger of the two.
So what prevents your client from filing a mod today? But for the fact that this appeal is pending, of course, but.
That is the sole reason. And there was some discussion prior to this appeal being filed, whether this appeal was an avenue to pursue or just filing a new mod was the avenue to pursue. And this is the decision that the client made and the route that we're currently traveling. But you're absolutely right. Depending on the outcome of this case, that may be the requirement.
Is there an argument to be made that former wife was really unclear that the durational, based on your client's initial pleading, which was a material and substantial change in circumstance, was not really on notice that she had to put in evidence of the durational limit because it occurred in the middle of the trial, and so she didn't have the time, and it really is a due process issue that she didn't have the opportunity to put in what she would need to put on a 53E case because it wasn't what was pled?
That's a fair question, and my answer to that would be if you look at the first couple of pages of the trial transcript where the two trial counsel and the judge are trying to figure out what exactly we're doing here, my brother says this is a durational limits case. There was a stipulation by the parties that the durational limits had expired about a month prior to trial, and both counsels sort of put durational limits on the table, and my brother was the one who said, this is the issue for this case. So I understand the court's concern about due process, but the record seems to reflect that Ms. Howe and her counsel were prepared to address the durational limits aspect of it in the evidence that they presented on that day. One other point with regard to the second argument in my brief, and I want to be clear or clarify with the court. The second argument, my client is asserting that she, Ms. Howe, needed to file something affirmatively in order to get this relief. In preparing for this oral argument, I found a line in George by Justice Lowry's petition that I had missed originally that completely turns that argument on its head. And I want to be candid with the court about that. That I now understand because of it's been 12 years now. We think about most of these cases as recipient sort of burden cases, but this is one of those exceptions where the divorce was granted prior to the act. That puts the moving party onto Mr. Zhang. However, the burden still remains with Ms. Howe. So that second argument, in preparing for oral argument, I came to find is not a valid argument. So
I appreciate that.
We'll clear the record of that right now.
Isn't there something more than a little bit weird about that, though? And I guess this is where one of the places my mind sort of gets tangled up thinking through the burdens here is, and this, I guess, goes back to the discussion about notice. It seems to me that one could conclude on this record that both parties were on notice, at least as of the time of the pretrial memo, that durational limits was at issue here.
Yes.
And as you've conceded, there is this piece of George that says, given the timing of this particular decree, it's actually on the payer to raise the issue. This is inarticulate, and I apologize in advance for that. But part of the point of notice, obviously, is so the other side knows what's going on. But I think we would all agree as litigants that part of the point of notice is so that you're prepared, if you're the person who has the burden, to come in and carry your burden.
Yeah.
And if the person who has the burden is not the person who brings the issue, one can end up in a situation, it seems like perhaps this is one of those situations, which should inure to your client's benefit, I guess, is your argument, where the person who has a burden doesn't really come ready to carry the burden.
Yeah, I got twisted up on that when I found that line in George. And my initial thought was, well, if my guy has to be the moving party, then my guy has the burden. Wait, this is a whole different case. And then the next paragraph, George clearly puts the burden on the recipient spouse in every case. So it is confusing when the moving party is not the one that has the burden. But the case law is unequivocally clear that the burden always rests with the recipient party.
I
And
think
in this
it's
case,
confusing here because it occurred in the middle of litigation. I think that if it had happened pre-litigation or in the 6-month lead-up that the statute in the cases contemplate, people know that there's a swinging pendulum. But this fact pattern is odd because it happened, he had litigation pending on a different theory, and then boom, the magic date hit.
yeah, I agree. And the only reason that I think that's not dispositive to uphold the judgment is because the parties on the record are very clear at the start of the trial that they know what's in front of them, and that there would have been an opportunity for either party to say, hold on a minute, Judge, this is a durational case. My client has a burden here. This is a new thing. We're not prepared. We need to back away and reschedule this trial or whatever the case may be. Both counsel affirmatively jumped in with both feet, so to speak, and said, this is the issue that we're putting before the court. And it's my client's opinion that the court abused its discretion in how it came to that conclusion with the factors. So I would ask this court to look at that and either vacate the judgment with a remand order to vacate the alimony or at least remand it for further findings.
Let me just check to make sure the panel has no additional questions. I see none. Counsel, thank you very much.
Thank you, Your Honors.
May it please the court.
Good morning. Let me just get the clock reset. Okay, go ahead.
May it please the court. My name is Wei Jia on behalf of appellee, Ms. Howe. And I have to apologize. English is not my first language, so I will try.
It has nothing to do with your language. It's your volume. Can you move your mic a little closer? Perfect.
Oops. Is that better?
Yes, it is. Thank you.
Okay, all right. Your Honors, I agree with what I heard the discussion before, and my clients bears the burden to prove that durational limit must be deviated, and evidence must be here now, as George versus George case, one of the guidelines that indicated. However, Judge Ross, in his opinion, adopted in the entirety of the prior Justice Giordano's decision, factual findings. And that finding detailed medical conditions of both parties at the time, which is about a year ago, and detailed about the husband's income and the wife's and the employability for unemployment for more than a decade. And George versus George, one of the guidelines in that case indicated that if we have a prior condition, if we have a condition that existed at the time of divorce or the prior modification proceedings, and those conditions persist until now, then those conditions need to be considered. So in light of that guideline, Judge Ross adopted in the entirety of the prior decision, factual findings, and made a decision of a deviation.
I'm troubled by that because it's clear that when you're looking at a complaint for modification, the probate and family court judge is required to go back to the prior judgment. And here it was the Judge Giordano modification judgment. The factual findings are the factual findings at that time. But I don't see how that alleviates your client's burden to demonstrate under 53E in the here and now that this is still the case. As we know in SS, there was a lot of information about the wife's medical and mental health history that was quite concerning, but it wasn't new. And so I'm troubled by that. I don't know how you can take findings from a prior modification trial and say that that suffices under George for the here and now.
Well, Judge Ross did not just only rely upon the prior findings. She also heard the testimony and indicated in her decision. And as to 53E factors, and Judge Ross did consider at least 1, 3, and 4. health insurance used to be provided by the husband and stopped. Life insurance, according to the separation agreement, needs to be provided by the husband and stopped. And also the illness, health conditions of both parties, those are all relevant, both in the prior findings and here now.
Do you feel that though her findings do reflect an accounting of and recognition and consideration of those factors? Because as I had asked earlier, her findings don't actually state the language.
I agree.
Correct?
That's my reading of the decision. I was thinking there's no explicit findings in the interest of justice and after consideration all those statutory factors. However, I agree with Justice Tan. There should be inference there because she considered and before finally reached the decision of deviation.
But Judge Ross didn't use the magic language, in the interest of justice. That's magic language.
That's a regret, yes.
So why don't we remand it?
I would agree to remand the case for further findings, yes.
Do you, I was sort of surprised by the disconnect between the language in the statute, which says the considerations may include, and then the language of the Supreme Judicial Court in George, which says, it doesn't say shall include, but it says you need to consider the relevant ones. Do you have a position on what those two things mean together?
Well, my reading of the Hasse case is, I think, is at least one of the factors needs to be considered. And you make, that's Georgia case, I believe, is that you may consider the statute factors of 53E.
Well, George says something kind of in the middle, which is something I highlighted and now can't find. The judge must consider all relevant statutorily specified factors, which seems to be a higher requirement than what is in the statute, at least to my just plain language reading of the statute, which the statute as drafted, to my uneducated eye, here's some stuff you might want to think about. And then George says, no. If it's relevant, you must think about the things in this list. But the statute is different from the one that Justice Blake quoted earlier, which says, you must tick each of these boxes.
I do remember Hasse case says at least one of the factors needs to be considered. I don't know what's that. That should be 53E is may include, the statute says that. Right. And Hasse cases may be based on one or more of the factors. And so there's a disconnect there.
You can't solve that problem for me.
Well, Your Honor, at least the Judge Ross considered three of those factors. And arguably, the 53E, numerical number 9, upon written findings, of course, there's no written finding, but I withdraw that statement.
So I'm troubled by something else Judge Ross said at paragraph 9 of her decision. She says, the fact that the presumptive durational limits were surpassed as of August 1st, 2023, is not controlling, except that the durational limits will be considered a material change in circumstance. That's contrary to the statute. That's contrary to the case law. I'm worried about whether or not she had sort of the right lens on in this trial. I mean, it's clear she did not credit much of what the former husband had to say. And if this wasn't a durational limits case on her findings on his credibility as to a material change in circumstance, I think this case is easy. But that's not what this case is about. And so did her misperception of the law and of what the statute requires so infect and taint her entire decision that this has to be a redo as opposed to a remand?
No, really, in my opinion, credibility is the issue of the husband, and there are multiple places that cause doubt. But
Absolutely.
Judge Ross consideration. She conducted a two-step analysis. Because the pleading, the complaint is only for material, is based on material change of circumstances. There's no amended complaint. So judge, the first step is to analyze the case based on that. And the conclusion is, and she said, apart from durational limit. So based on that first step analysis, she said, well, I don't see any material change of circumstances. And because the
I don't think husband's challenging that.
No, I just try to respond.
Probably a smart decision.
And then the second step analysis, because both parties agreed that the durational limit is the only issue at the time. So judge said, okay, I recognize durational limit itself represents material change of circumstance. So in other words, it follows, the analysis follows should be whether there's a deviation.
So that's where I think you and I might part ways, because I don't think that the cases or the statutes say that the durational limit is a material change in circumstance. I think the statute says a durational limit means alimony ends and the burden shifts to the recipient to prove a continued need in the interest of justice by clear and convincing evidence.
I am unable to cite the case, but according to my memory, there's a case that says durational limit itself. You don't have to approve material changes of circumstance. It's a self.
It's an automatic.
I'm sorry?
Isn't it an automatic? Once
Automatic,
the durational
yes.
limit
Automatic,
is
yes.
passed, automatically
Yes, that's a
alimony
material change of
terminates.
circumstance, but that's presumptive.
Okay, so let me change gears and ask you, tell me what the evidence is that you proved at trial to show that it's in the interest of justice for alimony to continue.
The wife can only rely upon Judge Ross's citation or adoption.
I want to know what you think you proved.
We proved that the wife's medical conditions continued for the past, since 2008. Medical conditions, including her thyroid titties and breast tumor. And she has not been employed for more than, since 2008, I believe. And as the judge, Durational find that there's no way for her to return to the job market at this point. And also the health insurance. She's only paying her health insurance out of the alimony payment to support herself, as well as there's a termination of life insurance coverage for her, which was the deal, a part of the deal of the separation agreement at the time. And so I rely entirely, for the most part, is the adoption of the prior factual findings.
And do we have in the appendix Judge Giordano's findings? Because I don't see them.
We don't.
What is the status of the alimony payments that were due as of the time of trial?
Well, that's another story.
Is it in the record?
It should be in the record because less than a year after the prior decision, December 2021, husband stopped payment, and the wife filed a complaint for contempt of court, and then that hearing dragged on because Dr. Zhang did not come to the court for several months. And eventually, Judge Ross issued an order, said you have to make arrangement for your bank for automatic bank payments. 7 days after that order, Dr. Zhang signed a flex employment agreement good for 1 year, and saying, okay, I'm not going to work full-time, I'm part-time now. And then less than a month, based on the flex agreement, she filed second modification complaint. So the alimony payment stopped before the second modification complaint was filed. The last payment was...
So she said he stopped paying in April of 2023, but in July she entered a TO that suspended it. That's what her decision at paragraphs 56 and 57 say as to the contempt.
Yes.
And the husband has not appealed the contempt. So
No.
that
Yeah.
is what it is.
Right.
Okay. And why are you entitled to fees?
I'm sorry?
Why are you entitled to fees?
Well, wife has a burden, financial burden to pay her fees. Actually,
But
I-
what, is it statutory authority? Under what authority are you asking us to award you fees?
statutory, but I don't have it with me at this moment, but yes, under statutory, yes.
Well, you cited Chapter 215, Section 45 in your brief. Is that?
Did I mention that? Okay, I forgot. The wife has a tremendous financial burden on herself right now at this point. And she's borrowing money to pay for her health insurance.
You do have some additional time. Let me just see if the panel has any questions. I don't see any. We're happy to take the rest of the argument on your brief.
I'll submit the rest on the.
Thank you. This matter is under advisement. Counsel, very nice job. We're going to temporarily